see me?
Yes.
We can see you, sir.
Okay. So good evening, everyone. Thank you, Neha and his team, her team actually giving me this opportunity. So I'm going to talk basically private air law. That is Warsaw system, or more particularly Montreal. Before that, I just 2-3 minutes I'll take about, why and how air law or aviation regulations. That is what I'm going to do that. When I say why air law, so I know today, tomorrow, day after, we are going to talk about all these things. But one basic question comes, do we need air law to regulate aviation? Yes. Why we need? Because aviation carries over 4 billion passengers annually. Friends, I'm giving you these statistics of 2019 because you all know that COVID, I call it a COVIDization. COVID has impacted the global governance, all sectors, and more particularly aviation sector has set back. That's why I'm giving these statistics of 2019. So 2019, if you look at, annually, the global aviation carriers carried 4 billion passengers. And every day, if you look at 120,000 flights depart, carrying around 12 million passengers per day, along with 18 billion worth of trade. This can't possible without regulation, without law. That is the point what I want to put here. Global air transport sector, you all know that, supports 65.5 million jobs. This is very interesting thing we have to make note. And it also contributes 2.7 trillion global, economic activity. And I can tell you, any given moment, if you look at 10,000 flights fly across the globe, and everybody has to follow same rules. That is where the regulations or air law comes into picture. That's the thing. And of course, I can go on talking about the other things, but primary why these are reasons. How aviation regulations can be happen. Of course, I'm going to focus more on one aspect, but before talk about aviation regulations or air law, you all know that it's a body of rules governing the use of airspace. Of course, friends, airspace is different from outer space. You all know that. That's why I'm talking about airspace. So this body of rules, if you look at, if you analyze, there are basically 3 important aspects of, if you ask me a question, sir, tell us in 2 minutes about international air law, I can tell, saying that, entire air law is based on the philosophy of international, I'm talking about, philosophy of who owns the land, owns the sky. Usa esta solam esta escu et colum. That is the Latin maxim. But who owns the land, who owns the sky. This is the philosophy of air law, and it more particularly applicable to all regimes. And if we had to analyze in very brief manner, entire air law can be looked at understanding of 3Ps formula. You know what is 3Ps? PPP. Of course, PPP nowadays people know about public-private partnership, more very used word. But I can say, tell you friends, PPP used, public air law, private air law, penal air law. So public air law deals with the Chicago regime. Of course, other speakers are there going to talk about that. But just in a minute, I want to give, public air law, or what we call Chicago regime, deals with general and, technical aspects of, aviation regulation. Of course, we have a Chicago Convention. Before that, aviation. Of course, law and technology goes together. You all know that, the moment when, Wright brother invented aircraft, and in the same month itself, global, players, particularly some of the European states, started talking about the regulation. That is where the birth of technology and law goes along. And most of these regulations identified with the Chicago relating to technical and, other general regulations. What I call Chicago regime. Chicago regime consisting of the Chicago Convention and the other conventions dealing with the general and technical aspects. Of course, I'm not going to focus on, but just this is for your information. Second is Warsaw system. Second P is, first one is public air law or Chicago regime. Second is private air law, or what we call liability regime. Private air law also called, you all know that, conflict of laws. Our Warsaw systems deals with a liability. So again, to put it, Warsaw system consisting of the Warsaw Convention 1929 and other conventions and protocols dealing with the liability issues. I'll dwell little, elaborate later on. So this is the second P. Third P is penal air law. Okay, that is called, safety security, mostly deals with safety, air security, all this. So this is what I thought, I'll say why air law and how, the international air law. So aviation regulations, if you look at, friends, broadly, every country, national regulations, bilateral regulations, regional, global. So of course, I'm going to focus more into global or international air law. I said understanding international air law can be understanding three-piece formula: public air law, Chicago regime; private air law, Warsaw system; criminal air law, or what we call the penal air law. That's it. So, and I think all these regimes, whether you talk about Chicago or Warsaw or any convention, the basic philosophy which I just mentioned is the who owns the land, so owns the sky. That is the point which I want to elaborate. Then, of course, since I'm going to talk about Warsaw system on aviation liability, or it deals with more particularly Montreal Convention. So, what do you mean by Warsaw system? Okay, Warsaw system. When I use the Warsaw regime, I call it because it's a broad word we used. Warsaw regime consisting of the Warsaw Convention 1929 and other conventions and protocols. You know what is a convention, what's a protocol, okay? So other conventions and protocols dealing with the liability. Liability of whose liability we are talking about? Liability of passengers, cargo, and destruction, damage of cargo, delay. Those things comes into Warsaw system. Of course, plethora of international treaties which deals with Warsaw system. Particularly the moment when I say Warsaw system, I had to mention Warsaw Convention. Warsaw Convention is the mother or important treaty dealing with the issues pertaining to the liability particularly. Of course, though, when I say Warsaw Convention, it is way back in 1929. 1929, 1920s, aviation was very, very rudimentary or not so developed that. So, but still, that convention actually dealt with the liability issues or private air law. So after 20s and First World War, Second World War, these are all, prompted to go for Warsaw Convention. So, but one thing relating to Warsaw system even now also is that, low liability system. Warsaw Convention way back in 1920, because if I had to talk about Montreal, this I had to give, 2-3 minutes background about the Warsaw, because Warsaw Convention is the source for Montreal. So this 1929 convention basically deals with all liability issues relating to that. But one issue, Warsaw Convention fixed the liability for passenger like 1,25,000 francs. Franco, it's a French currency because 1920s. So that time it was around like $8,000. But other things also it discussed issues relating to baggage and cargo, other things. So that's a Warsaw. But friends, one important developments happen. You all know the law is a dynamic and air law is more particularly dynamic in nature. So it is changing from time to time. So because of the liability regime is changing, so the international community came out with other conventions and protocols. And when I say protocol, friends, protocol is the supplementary to the convention. Okay, we have a Hague Protocol 1955. This is a very important thing. Some developments happened after 1929 to 1955. So much development happened. To incorporate these developments, they came out with one protocol that's called Hague Protocol of 1955, which changed the Warsaw Convention, mainly enhancing the liability regime of passengers from 1,25,000 francs to 2,50,000. It's doubling that thing. It's around like again $16,000 if you put it that. So that was the major development happened. And then later on again from the beginning in the Montreal or Warsaw liability regime is different between the developed and developing countries. Developing countries, developed countries always in favor of more enhanced liability regime. We developing countries were not supported that cause. That's why developed countries were not happy with the existing liability regime. So that's why they increased from 1,25,000 to 250, and still they were not happy. So more particularly America. So because America was not happy, and by the time 1960s, okay, early 60s, America threatened to actually I want to withdraw from the Warsaw system. That kind of threats came, and then to pacify, to satisfy, to appease the so America and mainly particularly USA. So the international communities came out with one international treaty that's called so-called Montreal Agreement of 1966. Why I'm using so-called? Because it's not an international treaty. It is an arrangement. It is an arrangement to satisfy the US issues That's why it called, so-called Montreal Agreement of 1966, enhancing the passengers liability again, like 1 lakh, 75,000 US dollars. So that including the attorney fee, or if you exclude attorney fee, it was, like 58,000 US dollars in 1966. I think it's a very rarity in international conventions talking about the, attorney fee. This is a convention which, talking about attorney fee, including, excluding. That shows how, aviation lawyers have, got important even in those days. That's what I want. So this Montreal Protocol is nothing but just to make happy America, but not many countries accepted. And then other developments in 1960s and 70s particularly happened, various protocols. But in 1975, one important development happened in the aviation liability regime is the protocols. That's called 4 Montreal Protocols of 1975. These 4 Montreal Protocols are nothing but changing the US dollar. Actually, earlier I said francs. It was a French currency that was created a lot of problems. Then changing from francs to SDRs. SDRs, you all know, friends, it is a IMF, special drawing rights. It is a monetary denomination of IMF. So they changed from, like, first protocol talking about the changing from, 1,25,000 into like 8,000 SDRs. Like second protocol talking about changing from, like 16,000 SDR is equivalent to dollar in those days. Now changed. So this is the thing, and these are all, of course, problems. But still the developed countries were not happy with the liability regime. That's why the Montreal Convention of 1999 came. Okay, so divided. The world is divided between developed, developing countries when it comes to liability regime. So to again, lot of issues happened with the developed countries. They were not happy. So that's why a comprehensive revision required, needed. That's why Montreal Convention 1919 is nothing but updating the Warsaw system. Warsaw system on the liability, whether it's for passenger or cargo or damage to, destruction to cargo, baggage, all those. Today, liability under Montreal Convention 1919 is nothing but updated, amended, revised version of the various liability regimes pertaining to the civil aviation sector. So today, if you look at liability, 1 lakh US dollars. So that is the change they made it, and of course they enhanced liability of baggage, liability of passengers, and except one thing which not changed from 1929. That's the Warsaw Convention till today is the cargo. 17 SDRs that was there in 1929 today is same thing, except that other lot of revisions happened and regimes have changed. So this is pertaining to the liability regime in general, and lot of new developments which the Montreal Convention brought, including enhancing fifth jurisdiction, enhancing the incorporating the insurance liability. Then it also enhanced the passenger liability, not only passenger but cargo, and also these new developments which incorporated in the Montreal Convention of 1999, keeping in view of the changing scenario. Of course, you all know that India is a party to all these international air law, whether it's a Chicago or other conventions. So India is a party to all these international treaties, and we incorporated these conventions into domestic law. Friends, you all know that international law or international air law has a limitations. The problem when you look at the domestic law with international law has some limitations, because international law deals with sovereign states. It is a law between sovereign states. So just to give a 1 minute idea, yes, not automatic. So when we look at international treaty, whether it's a Montreal or Warsaw or Chicago, how we implement in India, Indian context, if you look at, yes, we implement incorporating those international treaties into the domestic scenario. India follows the dualistic approach, what we call, we recognize that international law and domestic law are two different distinct bodies. If we have to implement international law or international air law or Warsaw or Montreal Convention, we have to adapt. So that's where we have dualistic approach, or then we call adoption theory. India follows specific adoption or transformation theory. Part of that, India, of course, party to all these international treaties, and we have domestic laws dealing with these international conventions. Particularly when I say that, earlier we used to, India was up to Warsaw Convention 1929 and a protocol, we have Carriage by Air Act 1972. But now the Carriage by Air Act is replaced 2009, incorporating the Montreal provisions, because India was the 91st member in ratifying the convention. So this is the one area. Just I thought I'll just update that. So then other aspect, because my title goes applicability, adoption scope of Montreal Convention, concept of liability, and other issues relating to the professional aviation professionals, scope and opportunity. Of course, today new developments are happening in the aviation sector. That is true with other sectors. Particularly, we hear about a lot on the globalization, liberalization, privatization. All these things are happening across the globe, and aviation sector is no exception to this. So globalization, of course, happening in all sector. I said just now, and more particularly in the aviation sector, it happened. It began with Air Corporation Act 1978 in the United States, and then it moved to Europe, Africa, America, all continents today. Almost all the countries now, part of the globalization are global. So globalization impacted aviation sector. There is no doubt, because of the growing, international economic, cultural, political, economic cooperation. All these things have, a lot of impact on that. So without doing into the, details about that, how India is, implemented this globalization process. Of course, when I say globalization, India is no exception to this. So India incorporated this globalization process. India, we all know that, friends, in 1990s, early 90s or 1991, we liberalized our economy. Okay, we call it, say, liberalization. Some countries say liberalization, deregulation, privatization. These are different terminology we use, but in India, the globalization process has been percolated to the Indian domestic context by incorporating a lot of changes in the global general Indian economy. So this happened. Why India has to globalize or liberalize its economy? You all know that mounting problems of financial debts, balance of payment crisis, foreign exchange, all these things which necessitated to become India part of the globe or global economy, and India took that. But aviation is part and parcel of the general economy. So the moment when general economy was liberalized, and then Indian aviation sector also started liberalizing, and the liberalization of Indian aviation sector started in, of course, mid 80s. It started with cargo, then we moved to passenger, all these things. So the impact of aviation on Indian sector began with the cargo, then passengers, and why we need, how we liberalize, we all know that. I'm not going to that, but today, because I have to talk about the prospects, that's why I just brought this idea of globalization, liberalization, privatization, deregulation, what you call in other parts. So India is incorporated these changes, and now in the sector, any sector you take, whether it's the liberalization, open sky policy, we call it in India open sky policy, repealing the Air Corporation Act 1953, and again we have a new Air Corporation Act 1994. Then airports, if you look at airport privatization, of course, I use here PPPs, lot of public-private partnerships happening in the airport, and we have a Airports Authority of India Act, and privatization of AIA, again incorporating various provisions. In the same airline privatization also happened, liberalizing FDI in aviation sectors, mergers, acquisition, competition. All these are all the new challenges which happening, and particularly what kind of opportunity we in India have in the aviation sector, or if I say scope of civil aviation growth. You all know that the aviation industry in India experiencing new era of expansion because of diversified factors such as low cost carriers, modern airports, foreign direct investments in domestic airlines, cutting edge information technology. These are some of the positive factors for aviation growth, and these are all again, contributing to the growth. So this is, and if you look at most of the time, I say that population is a liability, but friends, I can tell you when it comes to aviation sector, the population is an asset. Why I am saying this? Saying because the 1%, for example, today we have 130 or 140 crore population. If 1% of the population towards the other modes to aviation, We need hundreds of aircrafts, hundreds of airports. Do we have these? So this is where challenge comes and opportunities lies, I can tell you. So that is where the whole global aviation industry is eyeing on India, because of the potential which India has. When I say the potential which India, because of population, and today everybody is cautious about their timing and other things. So there is no doubt, of course, we have had problems. I'm not saying that, all went well. No, we till recently, if you look at, unfortunate thing about this great country is that we do not have had a aviation policy. How can you expect investments come and, investor can invest here? So of course we have a 2016 aviation policy to some extent, that is filling, and we need to have a more and more. But those were some of the hurdles we faced, and today things are changing, and a lot of new schemes. Other speaker also spoke about that. These are things which are happening. Keeping that in view as an academician, and I can tell you that there is no doubt opportunities are there. Global aviation world is eyeing on India. Not that they like you, but they have a selfish interest. The selfish interest is nothing but they have a lot of scope to invest in Indian airports or airlines, all these things, because they saturated, whether you take US or Europe, all saturation has come, but when it comes India, everything is new. That is where the lot of scope, opportunities are there, and keeping that in view as part of the academician or a professor of law, what I call is academic social responsibility. You all know, friends, actually earlier we used to talk about a lot on the CSR, corporate social responsibility, part of the 2013 Act. Now it became, part of the Companies Act 2013. But now I'm, talking about, CSR versus ASR. What do you mean by ASR? ASR is nothing but academic social responsibility. The part of the academic social responsibility, being India, emerging player, and also NALSAR is one of the top law schools, second or third, whatever. So we design certain courses keeping in view of the future requirements of the aviation industry, and I can share with you in a minute or two. So we have designed some courses like, combining law with the technology, law with the management. Today, we are living in an era where the interdisciplinarity will work. Single, either law or technology won't work. That's why we in NALSAR have designed some courses, keeping in view of this interdisciplinary approach, online courses, then, using the technology. So combining law and management. When I say law and management, so these are the courses. If you look at aviation, start with the basics of, law, like introduction to law, the international air law, domestic air law, liability law, like that we have a design. Similarly with management also, like basics, principles of management to airport management, airline management, airspace management, air traffic management, because we need, unfortunately, aviation education is not there in India. That is what, prompted us to think about, and we are, this is accessible to, affordable and accessible. Our approach is to aerospace education at the doorsteps of the needy with affordable cost. This is our thing, and we are offering these courses. This is what I call it, say, again, academic social responsibility. If you say that NALSAR is the best law school, what is the contribution of NALSAR to the aviation sector? Friends, we have a full-fledged department. I think, subject to correction, this is the only department, in India, full-fledged working on the aerospace defense laws, and, particularly aviation sector. We have a master's program, diploma programs, and other certificate programs. All these things last 6-7 years we are offering. So with this, why I referred this is, we have a definitely, there is no doubt the scope and opportunities are, ahead, and we have to prepare to take that challenge or that kind of opportunities. That's the point I wish to, put forward here. And thank you for giving me this opportunity, everyone, particularly organizers. Thank you. And any question, I am happy to again respond to that.
Yes, sir. First of all, sir, thank you for the wonderful and this instilling information all about the protocols, the new definitions for PPP. One will always remember, uh, and uh, and commendable job, sir, at the initiative that you're taking with the courses that you've designed within NALSA for aviation law. Very, very commendable, sir. Just a couple of questions, sir, that I will take. So there are just a couple of questions. For example, someone had asked, what are the various defense pleas that can be raised by the air carriers under the Warsaw Convention?
Of course, and defense civil aviation is completely different from the defense aviation. Defense aviation is different, and because that comes part of the Ministry of Defense. Though the Chicago Convention or liability, all these things are only related to the civilian sector, not applicable to the defense. We have a separate laws to deal with defense. We have Air Force Act, Army Act, Navy Act, Coast Guard Act, all those. So that is a completely different thing. But there are certain issues, challenges which we are facing in, for instance, airspace management, air traffic management. Today, the issues which are happening within the country is that how to manage airspace, like defense airspace and civilian airspace. This kind of issues coming, but when it comes to liability, complete liability is a different domain. And India being a party to the Warsaw Convention and Montreal Convention, we are implementing through our domestic legislations, friends. So defense laws won't figure into the civil aviation sector. That's my.
Right. Thank you, sir. Just another question, sir. Someone has asked, Pradyuman has asked, is there a difference in protection of carriage of goods in the Warsaw regime under the air law and the CISG rules like the Vienna Convention under maritime law?
Yes, there are different rules. This deals with, like I said, Warsaw Convention or Montreal Convention, deals with what? Liability. Liability of whose liability we are talking? Passengers liability. Injury or death of passenger. Other issue is cargo. So coming to his question, actually, we have a cargo. So delay of cargo, destruction of cargo, damage of cargo, all these things part of the, I can say that Warsaw earlier and present thing. So we have, so if destruction or damage happened, what is the liability? Like 4,000 US dollars, SDRs, like we have said. So this is only when you have a cargo, air cargo. That's what when it's something relating to air cargo. This is the regime which deals with that. So PP is very well defined in this perspective. Okay. Somebody was asking something PPP. Of course, I said PPP in different contexts, just to remember, if somebody is new, this thing, I said, you can remember if I say public air law, private air law, penal air law, easily to remember, I use that word. But otherwise, definitely PPP is today only deal with, public-private partnerships. Okay.
Yes. Yes, so I'll just pick up one last question. So Shaurya has asked us whether air acts were repealed at the time of liberation of the industry.
We have done. Unfortunately, one thing is if you look at domestic air law, we begin with Aircraft Act 911. But of course that was no more. Aircraft Act 1934 is the legislation, the master. If you say that I'm using the word the are important legislation, though title is that Aircraft Act 1934. But if you look at, friends, we have done so far 9 amendments, major amendments relating to incorporating the changes. You may ask questions, sir, why if every time when new amendments are happening, why we keep 34? Of course, Indian Evidence Act, all those, we have a British legacy, we keep that, but we are amending, updating in tune with the global and domestic developments, and we incorporated in the domestic law. Aircraft Act is the master or importantly, and different regimes specific. For example, liability. I said Carriage by Air Act 1972. Today we have a Carriage by Air Act 2019 because India is a party to the Montreal Convention to update that. Like that, if safety security, I didn't talk about, like we have a safety, Tokyo Convention, Hague Convention, Montreal Convention, Montreal Protocol. To deal with these international conventions, we have a Tokyo Convention Act 1975, Hague Convention Act 1982. Then we have these are other legislations we India incorporate part of the international treaties.
Thank you so much, sir. Thank you so much for taking these questions, sir, and thank you for this wonderful presentation, sir, today.
Thank you. I hope I am on time, and I thank you very much.
Absolutely.
Thank you, sir. This has been an absolute pleasure, and I have been interacting, following you for a very, very long time. and this has been absolutely incredible. My takeaway is going to be the academic social responsibility, the new terminology. I think we are taking a few with us, and look forward to collaborating with NALSAR.
Sorry, Neha, in recent past, I am doing a lot of writings on the CSR versus ASR. If you look at, academic social responsibility, if you want somebody to read, because now it is everybody's responsibility. I'm sorry, 1 minute I'm taking. It is an individual responsibility. Then it goes to, institutional responsibility. What we are giving back to the society. So that is where the new term I am using, the academics, social responsibility.